amongst the things that the state noticed in their aggravating circumstances. So wherever there's a reference in the pattern that included something about aggravated battery, that has been removed. On page 1, second full paragraph, there's a parenthetical in there that says, in both stages of this proceeding, as there was no additional evidence presented in the second stage of the proceedings, I would propose that that parenthetical be removed. So it would read, in arriving at this determination, you are authorized to consider all the evidence received here in court presented by the state and the defendant. There is a period that needs to be at the end of the last full paragraph on page 4. That might have already actually been corrected in the ones that you have in front of you. On page 5, the first full paragraph is Turner or victim impact evidence. There was no Turner or victim impact evidence presented by the state, so that first full paragraph on page 5 will need to be removed. And those are all the amendments or changes to the draft that I think are appropriate. Any other suggested changes, Mr. Porter or Ms. Jones?
No, Your Honor.
No.
Any other suggested changes or improvements, Ms. Moss?
No, Your Honor.
All right, then with those amendments, that will be the charge that we're going to use in the case. I have also prepared a verdict form. The verdict form is in 2 parts. First part deals with the aggravating circumstances. There's actually 2 possible aggravating circumstances. Unlike the verdict in the first stage of the trial, what it requires is the jury eliminate or cross out those sections that are not applicable, leaving only their findings with respect to the aggravating circumstances. The second part of it is, of course, the actual imposition and recommendation as to a sentence with the 3 sentencing alternatives that are available there. It separately requires another signature by the foreperson. Have you had a chance to review the proposed verdict form, Mr. Porter?
I have, Your Honor. It's currently with you.
Any suggested changes, sir?
None from the state.
Any suggested changes, Ms. Moss? If you would please give it back to Mr. Porter, then that'll be the agreed upon verdict form which we'll use. Thank you so very much, sir. All right, we have another unified appeal checklist to review. Unified appeal, Uniform Superior Court Rule 34, Section 3B2, after the close of evidence. The following matters shall be concluded during the conference. A, written request to charge shall be presented to the court for ruling. The court has ruled. We've conducted our charge conference. That matter is concluded. B, the court shall make a final rule on any issues raised during the sentencing phase of the trial as to which a tentative ruling or no ruling was made during the presentation of the evidence. Mr. Porter, are you aware of any rulings that have not yet been made by the court?
No, Your Honor.
Ms. Moss?
No, Your Honor.
Section C, the court shall again review Part 4 of the checklist with defense counsel and the prosecuting attorney and shall hear any timely and otherwise proper motions or objections the defense wishes to present. Part 4 of the checklist, which deals with trial proceedings in the sentencing phase. Part A deals with opening statements. Part B deals with issues that might arise regarding the admissibility of evidence. Part C deals with issues concerning specific statutory aggravating circumstances pursuant to OCGA Section 171030B. Part D deals with issues that might arise in connection with the closing arguments. Section E deals with issues that might arise in connection with the court's charge, and Section F with issues that might arise in connection with the verdict. Ms. Moss, you've had the unified appeal as well as all the checklists. You understand what's on the checklist, ma'am?
Yes, sir.
And Mr. Porter, is there anything else on the checklist that needs to be reviewed?
No, Your Honor.
Defense counsel should be given an opportunity to perfect the record by making any tender of proof as to any evidence that was excluded by the court. Ms. Moss, do you have any tender that you want to make to the court at this time?
No, sir.
If the court determines that a mistake was made in the exclusion of potentially mitigating evidence, the court shall reopen the evidence and allow its presentation to the jury. The court is not of the opinion that any such Evidence was excluded and will not be reopening the evidence. Part D, defense counsel should be advised that objections, that would be you in this case, ma'am, objections to the state's sentencing phase closing argument will be waived if not raised as soon as grounds for such objection are raised, unless explicit permission is granted to reserve the objection until the conclusion of argument. Do you understand that, Ms. Moss?
Yes, Your Honor.
Okay. And E, the court shall give the defendant an opportunity to state any objections he or she may have to defense counsel or the manner in which defense counsel have conducted or are conducting the defense. Is there anything you wish to address to the court with respect to that, ma'am?
No, sir, Your Honor.
All right. Unlike closing arguments in the guilt-innocence phase, the state goes first. The defendant has the opportunity for the last word. Is there anything on the part of the state before we call the jury back in?
No, Your Honor.
Anything on the part of the defense before we call the jury back in?
No, Your Honor.
Please bring our jury.